It's an absolute pleasure and a privilege to be here today and surrounded by many friends and also family, my dad, my sister Carolyn and my beautiful daughter, to talk to you today and particularly to deliver what has become the established tradition of the Hal Wootten Lecture. It's an even greater pleasure to have that namesake of its lecture series, that you, Hal, are here and present to respond to my small contribution. It's a great honour and a privilege to have you and also your beautiful wife. Wonderful to have you here. I wish that there was more of this kind of tradition, not only in lecture series, but also in life, where we pause to celebrate and engage with a community of experience and ideas with the legacy of those still amongst us. Hal has described the lecture series named in his honour as an opportunity for the speaker to talk about their life in law, to reflect on their obligations, their responsibilities as lawyers, and how they've used this to shape a society where social justice is held dear. And it's also an opportunity for the speaker to reflect on how they've used the law and the person they've become to initiate reforms which uphold the rights of the vulnerable. Social justice has been my life's work, so it's a great honour to be speaking tonight. Recently, I enjoyed an afternoon reading through the impressive lectures which were delivered since this series' inception. And I have to say I took equal pleasure from your responses, Hal, as I did to the lectures, as you highlighted your philosophy on the law's place in society. So I want to just say that I'm just so delighted to have been asked by George to come and speak to you to deliver the oration tonight. I also want to start by acknowledging, as George did, that we're meeting on the lands of a Bedigal people, and to pay my respects to elders past and present and to any Aboriginal and Torres Strait Islander people in the audience tonight. This lecture series is designed as an opportunity for organic and respectful exchange, and it's exactly the model that the University of New South Wales Law School put forth over 4 decades ago. Eschewing the convention of the traditional lecture, the University of New South Wales took what was then a radical approach. It was an approach pioneered by Hal and chose to offer smaller class sizes in law, one in which students and academics shared in an exchange of ideas and mutual learning. And I have to say that was the thing that attracted me the most to this law school, the fact of the format of how the law degree ran. And that was radical in many ways because the university signalled the view, and Hal signalled the view, that the law itself was neither static nor an island, that it evolves, that it adapts to community standards, as Sir Gerard Brennan's very illuminating lecture explained, that it's influenced by other disciplines, by politics and by timing, that it can entrench power as well as challenge it. Those of us privileged enough to have received a legal education, therefore, also share a responsibility to ensure that respect, ethics and integrity lie at the core of what we do, that community confidence in our work remains paramount, and that we use our experience and our education to make the world a more just place. And as the words in the hall on the ground floor, and I love the mission statement for the University of New South Wales Law School, as those words remind us that we ensure that the law is not brought to bear unduly on the vulnerable. And that still rings true today. As David Dixon, his welcome address to students in 2014 explained, he said, the University of New South Wales law degree is not just about gaining a qualification in order to reap personal benefit from the world. Rather, it's about taking this qualification out into the world so as to inform whatever else you happen to be doing, whether that is as an artist, an athlete, or indeed as an advocate for democracy. In other words, what I learned from this law school is that we are all on this journey of serving the interests of law together, and that we can inform the lessons that we take from it rather than just parroting an unchanging truth. For me, this has meant accepting that I'm not only likely to remain an advocate and a reformer throughout my life, but a restless one at that, someone who continually adds to their reforming toolbox along the way. So today then, I'd like to share a little about my life in law, the decisions that not only took me to this great law school, but then which propelled my career, as well as the things that I've learnt along the way. So given my background, and just looking at the choice to pursue law, a career in law could be seen by some as a bit of a surprising decision. My father was a physician, my mother was a science graduate, my sister here is a senior academic in the medical school and the chief medical officer for Tennis Australia. My other sister, a professor in the medical school at Sydney University. So I came from a deeply medical family, and here I was choosing to do a law degree. We all grew up in my father's medical practice. It was a practice that combined being a physician with a new strain of medicine, which was nuclear technology. So Dad established the first nuclear technology private practice in Australia in about 1966, having introduced the discipline to St George Hospital when he was medical superintendent. And I still remember, even as a young kid, that we started experimenting with technology. We were able to transmit the images from Dad's private practice to the hospital electronically, which is now an absolute everyday occurrence. But back in the 1970s, this was really exciting and radical technology. And I did odd jobs after school, and once when my twin sister and I, we both got our driver's licence, Dad and Mum decided it was a good idea if we could ferry the patients from the hospital back to Mum and Dad's surgery. I mean, you know, whatever suggested that would be a good idea, I don't know. We had jobs typing the medical letters, and I subsequently became chief medical consultant to my fellow students and eventually the partners in my law firm. But I have to say, I think it was in transporting the patients and coming into close contact with them that I got my first glimpse of what I wanted to do in my career. Because it was on one of these trips that I remember ferrying a young woman with a suspected pulmonary embolus, a clot in her lung. And I helped her into the car. She had all the drips. I was a proud, newly minted driver. I helped her into the car, and as we're driving along, she says to me, she said, now tell me about your family. Do you have any brothers or sisters? I said, yes, I've got 3 sisters. She looked at me, she said, oh no, your poor father, no sons. Who's going to carry on the family name? I was like, stop the car, dump her out with her. I'm glad to say I didn't actually do that, but perhaps it was that experience that really propelled me into my subsequent role as Australia's Sex Discrimination Commissioner. I'm not sure, maybe I have her to thank for it. But I think my early life experience meant that I'd never lose my love of technology or indeed my desire to change lives. So against this background, I was constantly immersed in science and maths. I went to an all-girls school. So I was never exposed to the pernicious trend in which girls were discouraged from developing skills in STEM. Blissfully unaware of the gendered association, and some of you might know about the Harvard Implicit Associate Test, which tested more than 500,000 people around the world, men and women, girls and boys. It found that 70% of the test takers associated male with science and female with the arts. But I wasn't aware of that gendered association, fortunately, so my decision to come here to University of New South Wales was quite an easy one. I was drawn to the law because my 18-year-old self told me that law was a profession where you could have both a strong career and a family. I mean, I don't know what I was thinking at that time. But not only that you could help build strong societies by elevating the voices of those rarely heard, that a law degree was a strong foundation for so many interesting roles, and I see that so much reflected today. And University of New South Wales at that time was the only law school, in keeping with its emphasis on all-round learning, which actually had offered a combined computer science and law degree. So it wasn't then until I got to university where I chose to study chemistry, computer science, and other things together with law that any gender imbalance confronted me. I still remember turning up to my first digital logic and assembler programming class in the School of Engineering. I mean, it took me like a week to even say the name of a subject. I turned up 100 men and me. I knew pretty early on that if I was to have any chance of passing this course, which was about programming in zeros and ones, that I would need to trade my essay writing skills for some lengthy computer programming tutoring. And with my grades underpinned by this symbiotic relationship, I have to say we all got along very nicely. They would sit up and do my computer programs, I would sit up and do their essays, and we all passed. But as one of only 3 women in my year doing a combined IT and law degree at the university at that time, I finally graduated in the mid-80s in 1984. And following several years working and living overseas, I came back to Australia, and it was at a time when the World Wide Web was just starting to come to come into not just offices, but come into our lives. Technology was providing a wave of opportunity, a wave that I was able to ride by firstly accepting a job at what was then called Dawson Waldron, which is, as George said, is now Ashurst, a global law firm. And I accepted a role to establish their first ever legal technology practice. Now, I learnt some important things here because my colleagues were so sceptical. They told me I was wasting my law degree. It could be career suicide, they warned. Don't you want to be a real lawyer, they said. Self-awareness, however, is a crucial life companion, and my passion was to create a new way of delivering legal services, one that would demystify the law, make it more accessible and less expensive, just as the emergence of other forms of technology had made medical breakthroughs all those years ago back in my father's surgery. And my first assignment as the new head of a legal technology group, which consisted of me and my assistant, sounded very grand, it was the 2 of us. My first assignment was to set up the technology and the management of evidence for a large case up in Papua New Guinea, what was called the Octedi mine case. Some of you may remember it. It was to be heard in the Supreme Court of Port Moresby. The top of a mountain had collapsed into the Octedi tailings dam at a cost of $130 million, and there was a dispute. Not surprisingly, a dispute over who would pay. Would it be the operator, BHP, or indeed their insurers? Now, the case preparations were going along fine. We briefed some fine silks from the bar. I was in charge of designing the state-of-the-art networking systems running from the Supreme Court to the hotel. But what we didn't know, and more importantly, what I didn't know, and what I hadn't calculated on, was that the court hadn't paid their telephone bill for the last 4 years, and as a result, all telecommunications to the court had been cut off. Now, I thought that was bad. So did my client, so did everyone else on the legal team. But matters actually went from bad to worse, because the next day, just as I was about to get up there, I received a call from Data General, who were the company who were to provide us with the IT support on the ground. That task would not now be possible, they told me, because the man who was to provide the IT support had been axed, and I don't mean sacked. He'd actually been split down the middle in an attempted robbery. So when on the first day of a trial, the client brought around a huge machete to keep near the door just in case, I was really wondering whether I'd made the right decision to move out of law and into legal technology. But after 1 week of hearing, as so often happens, the plaintiff and the defendant decided that arbitration was looking like a much easier option, and we all breathed a collective sigh of relief, me in particular. But I think what that first case taught me was Murphy's Law, that if something can go wrong, it will. But I also learned about disruption. I learnt that for change to happen, you must disrupt the status quo. And I think this goes for the law just as much as technology. Because in Papua New Guinea, at that occasion, we saw an example of why formal access to the law is not necessarily enough, and why human beings can either make or break a situation. And we need to be alive to this as well as to be continually questioning what is valuable about traditional approaches and what is not. And that's also so true for gender equality. So by 1991, as I said, I was the head of a legal technology group. We grew that group initially to 8 lawyers, and I had a day that started like any other day. Then that morning, one of my lawyers came in and said, "Guess what, Liz? Happy news, I'm pregnant." "Oh, that's terrific," I said. "When will you be having parental leave?" So we worked that out. Well, then that same afternoon, another senior lawyer, one of my lawyers, came to see me and said, "Guess what? I'm going to have a baby." "Oh, that's fantastic. When will you be having your parental leave?" Well, when 3 weeks later, a third lawyer joined the mother-to-be queue, and what they didn't know was that I was also pregnant. We had 50% of the legal team out on maternity leave at exactly the same time. I don't know whether you remember that, George. We were saying maybe it's something they're putting in the water down here in the legal technology group. But that was the half the entire legal team. And as the person in charge, I had to find solutions and find them fast. My premise was simple. Work and care should never sit at opposite ends of one hard choice. It's pure common sense. If a workplace is flexible and allows workers to both balance work and life, it will allow for greater retention of talented staff, and that will lead to higher productivity. So you don't even have to go to the human rights case. And we decided not to ask for permission, but rather we would step up as a team and take action. We needed individuals who shared this new way of working. And I still remember we decided to go out for a junior secretary. We'd go out to the market and recruit a new secretary. I was presented with a huge list of CVs, and I came into the middle, and there was Michelle. Now, Michelle had been a secretary for about 3 weeks, but she'd been a nanny for 6 years. And with those credentials, we absolutely needed her on our team. So thinking outside the square, we developed a whole range of flexible work arrangement. People came and went. We set up various, the cots in the war room, the litigation room, which was in the room next door. I still remember one of the general counsel saying, "Oh, is that a baby I can hear?" "Oh, no, I wouldn't think so. This is a law office," I said. And what we did was actually put people at the centre of the solution rather than maintaining the status quo for the sake of a status quo. And over that next 10 years, we went on to build a really high-impact team where flexibility was absolutely core to the way we worked. So this was in the early 90s. It was at a time when flexibility wasn't widespread in law firms. But what I learnt then was a little like Paul Kelly's song, that out of small things, big things grow. And it's something that I've experienced so much across my legal career, and I'm pleased to look around law firms today and see 25% of people work in flexible work arrangements. So I then continued to build my career at Ashurst, or Blake Dawson as it was then, and I was able to spend time in an internet incubator. These were exciting times, the mid-90s, the dot-com boom. We toiled away, we reimagined new models for the new service delivery models. Services such as legallastminute.com, where law firms could even out the ebbs and flows of supply and demand. We started by recognising that a billable hour is a perishable good. If you don't sell it today, it's not worth anything tomorrow. So our web services concept allowed law firms to sell excess capacity into legallastminute.com, and clients could then buy forward at a discount. We also experimented with artificial intelligence. So what did I learn from the period in the incubator? I learnt that being 20 years ahead of a game is as problematic as being 20 years behind it. We started a couple of e-ventures in the early 90s. One of them's continuing on today, but the rest of them had crashed and burned reasonably quite early on. But I'd learnt about disruption, and that was a learning that I've taken into the work that I've done in social justice. Because by the early 2000s, I came to realise more fully the struggles for women, particularly in large law firms. The loss of valuable female talent, the fact that few females ever made it to the top. And it was from then on that I really became passionate about trying to change the system, or the systems that were producing disadvantage for women. This desire to fix the system rather than fix the women has been a lifelong mantra. And I have to say, even today, I see so many strategies which are focusing on fixing and changing women rather than changing the system so that both men and women can thrive equally. But how do you fix a system? And I needed to fall back on the lessons that I'd learned here at the law school. I realised that I had a responsibility to use my voice and experience to advocate for the rights of women and to create a more gender equal and just society from which everyone would benefit, not just women, but men, families, societies, economies, nations, and not just law firms. And certainly over the last few years, the work of promoting gender equality is becoming more and more difficult. Each day, I sense that our progress towards gender equality is slowing, that hostility to human rights is actually growing. Whilst I don't have clear data from this, my meetings with human rights defenders all across the world tell me it is so. And just last week, I returned from several weeks in Pakistan, India, and Sri Lanka, where once again I heard from human rights defenders that women's rights around the globe are facing an alarming backlash. As the UN Independent Expert Group on Discrimination Against Women warns, the world is at a crossroads with the very concept of gender equality being increasingly contested in some quarters. So over the last few years, I've learnt a number of extraordinary things. I've come firstly, and my first learning is to understand that law and reform must be about people, that the rule of law and democracy are not there to serve an academic ideal, but rather to serve ordinary communities and individuals. We don't take action because of the statistics we read or the legal principles we've considered. Rather, we take action because of our interactions with other human beings. So in all my dealings, I hold the experiences and the stories of individual people in the forefront of my mind, as that's what keeps me driven. That's what keeps me emotionally replenished. I describe it as holding my compassionate self, the part of me that is the keeper of so many thousands of stories. To hold that part of myself beside my strategic self, the part of me that engages in reform and advocacy. So when I step up to advocate for change, it's not just Liz Broderick speaking. It's Liz Broderick fueled by the thousands of instances of inequality I've witnessed over so many decades. That's what fuels me. That's what helps me become influential. And as Sex Discrimination Commissioner and since, I've met extraordinary, inspiring and everyday people, people whose stories remind me that gender equality goes to the heart of who we are and how we live. That while we might have formal equality in our statutes, equality is not the lived experience for so many Australians, so many people across the world. Let me just share with you a couple of the stories that come to mind. I remember Lurleen. Picture this, I'm in Hobart. I'm visiting the women's refuges. Lurleen's running a young women's refuge. Every day she makes sure that girls escaping violence, substance abuse, poverty, that they have food, that they have a warm bed, that they have access to education. And on the morning I arrive to meet with Lurleen, she's been up at 2 a.m. to resolve a dispute between one resident and her boyfriend. She's up again at 3:30 a.m. to call the police because the boyfriend's come to torch the refuge. And then finally at 6 a.m. to get those girls to school. But like so many in the community sector, Lurleen's role is unrelenting. She's 72 years old and she should have the option of retiring from paid work. But for her, the price of a lifetime spent in the caring industry, also caring for her own family, is to be consigned to poverty in later life. So meeting Lurleen prompted me to ask and to reframe some of these issues. I started to ask, is poverty a just reward for a lifetime spent caring? Because that's where so many older women in our nation are at. Do I have a responsibility to try and change that? Absolutely. Now see Maria I'm in Western Australia now, and Maria's working hard in the construction industry. Many of us would take for granted today the capacity to both have a career and a family. It's the 21st century. But when Maria announces her pregnancy, her manager's response, "Maria, your choice, the job or the baby." And the consequences for Maria's hastily made choice are later devastating. So Maria taught me that decisions that are made by those in power have an impact on individual lives, that work and care should never sit at opposite ends of one hard choice, and that it's my responsibility to step up and use my voice for change. And then finally, picture Jane. Jane's a young woman in our armed forces who I meet in Queensland. She ducks her course, she excels in her training, just the kind of woman the military would nurture and encourage. Yet she's subjected to extreme bullying and exclusion, turned backs, no one speaking to her on exercise, alone for meals at the mess when her colleagues banter at the next table. Her participation to serve her nation, her one dream, comes at immense personal cost. Yet she finds the courage to speak out, and by doing so, she reminds us that words can be powerful beyond belief. She really taught me that I must use the influence that I have to create command and control organisations in our nation where women can thrive equally with men. So every one of these stories, and the thousands of stories that I've heard over at least the last decade and a half, they echo the feminist adage that the personal is political, reminding me constantly that the lived experience of inequality, of exclusion, of hardship is what matters. What's more, the personal is precisely the thing that will ultimately spark change. It's the stories that will enable us to take the next step forward. And in taking the next step forward, the second lesson I've come to understand is that if we're to create change, we have to take these human stories directly to the heart of power. My job is to identify where power resides within organisations, within nations, and then to take the human stories directly there. In 2011, I led a review into the treatment of women in Australia's Defence Force. And as I travelled across Australia and beyond, and I went to around 60 bases, into Black Hawks and submarines and frigates, people told me their stories about how the ADF had, on most occasions served them incredibly well. But on occasion I heard deeply distressing stories like Jane, stories that had never been told before. And as I started to go through the journey, I realised it was important for me to hear the stories and put them in my reports because I was tabling them in the Parliament. But what was more important was that those people who had the power to change the system, to redress the wrongs, in other words, powerful men, heard these stories firsthand. So I made arrangements to fly in women from all over Australia. Many of them chose to bring their mothers as support person, and to sit down one-on-one with the Chief of Navy, the Chief of Army, the Chief of Air Force, other senior personnel who could hear from the women themselves what extreme exclusion feels like, what it's like to be on exercise for months when no one speaks to you, what it's like to be sexually assaulted by your instructor, the very person you go to for advice, what it means to have your career ruined because you had the courage to speak out. And I'll certainly never forget that first face-to-face session that we organised at the Australian Human Rights Commission. The relevant service chief arriving early, sitting uncomfortably in his chair, the mother nervously escorting her daughter into the room, the box of tissues in the middle. And the question was, how would we get this conversation going? These are not easy conversations to have. But it was that young woman, that courageous young woman, she turned to the chief and she said, "Sir, I am so nervous." And he looked at her and said, "Believe me, I'm scared too." And I knew that in that moment we had a chance at change, because it takes a courageous young woman and an authentic and compassionate military leader to admit that he fears what is about to be told. There is no way to unhear, unfeel, unsee the stories, the human impact of culture on individuals, and that's what the service chiefs heard. They also heard the heartbreak of mothers who had encouraged their daughters into the service, believing the enemy lay outside. One mother turned to the chief and she said, "I gave you the person I love most in the world, and this is how you've treated her." There are no words that can adequately respond to that. And I have to say, working with the ADF has been one of the greatest privileges of my life. It's an incredible organisation. The military chiefs demonstrated enormous courage and compassion. But those sessions taught me that in order to change the system, we have to take the human stories directly to the heart of power. That it's through hearing and feeling exclusion's consequences firsthand that we start to plant the seeds of reform. This work also made me think more about systems change and whether women alone would be able to change the systems. Because it seemed to me that most of the systems that operate, not just in Australia but around the world today, have been designed by men for men, the legal system being no different. And as Gordon Cairns, one of our male champions of change, and he's the chair of Woolworths, explains, he says, "Let's not pretend that there aren't already established norms that advantage men. Men invented the system, men largely run the system, men need to step up beside women to change the system." And this is when I really came to firmly believe that if we want to create a more gender equal Australia, we actually have to focus on men. It's about men taking the message of gender equality to other men. That's what's going to shift and disrupt the system. That's not to undervalue or underestimate in any way the value of a collective action of women. Because let's face it, that's what's got us largely to where we are today. But we need an additional strategy. So with this epiphany, several years ago, I decided if that's the case, I'm going to pick up the phone and ring some of the most influential men in the nation. And that's what I did. I rang men who led Australia's iconic companies like Telstra, Qantas, the Commonwealth Bank, Woolworths. I rang men who led global organisations like Citibank and IBM, men who held the most senior positions in our governments like the head of Prime Minister and Cabinet, the head of a Treasury, the head of our intelligence agencies. And I made a personal plea. I said, will you use your power and influence, your collective voice and wisdom to pursue gender equality in Australia? And I still remember the first conversation I had. I spoke to the CEO of IBM, a terrific guy, Glenn Barham. He had twins, a boy and a girl. And I explained to him that in Australia at that time, women only held 3% of CEO positions, that there were more men named Peter than women at the top of ASX 200 companies. I don't even really know what that stat is, but I know it's not very good. And that women only occupied 8% of board positions. And not only that, that those results persisted despite women representing more than 60% of university graduates and almost 51% of the Australian population. And I think what shifted for Glenn was that he started to understand that without intervention by powerful, decent men, that this story would become his daughter's story. That his daughter would never have the same opportunity to thrive as her twin brother, purely because she was born a girl. So with that in mind, I remember our first get-together. It was a little bit like that first computer science digital logic class, although much more interesting, I have to say. 21 A-type personalities, male personalities and me, some having travelled thousands of miles to get there. And I remember one of the champions said at that meeting, he said, "This issue is not beyond our capacity to solve. Excuses are just that." And from that meeting, the Male Champions of Change strategy was born. So it started small, 8 people. We're now at 160 male champions today across every sector, from the fire and emergency through to intelligence agencies, federal police, private sector, government, sport. Male Champions of Change sport. It's fantastic to see what's happening with women's sport in the nation. So leading some of a disruptive edge to create more gender equal Australia. And the strategy is disruptive. It's controversial. I often hear people saying, well, wait a tick, Liz, are you suggesting that women are waiting to be saved by corporate knights in shining armour, galloping paternalistically into territory that has been our territory for years? This couldn't be further from the truth. Women's voices remain absolutely critical to advancing gender equality and eliminating violence against women. But what I do know is that the achievement of gender equality cannot sit solely on the shoulders of women. Because firstly, women largely don't hold the levers of power, but secondly, if we allow that to happen, any failure to make progress will also be laid at the feet of women. So this issue of gender equality is not a women's issue. It's a key economic and social issue which affects everyone. And when men step up together and take shared ownership, that's when we stride forward. So then just quickly fast forwarding to the present, over the last year or so, as George said, I've come to focus on the place of university residential colleges in Australia and the confidence which the community places in them. And you will know, for many of you probably have been to college, that the residential colleges have nurtured the young minds of so many of our powerful men and women across Australia, so many influential alumni from law. Alumni like Herb Everett from St Andrews College, who was the youngest ever Justice of a High Court and the former President of a UN General Assembly. Sybil Morrison from Women's College, the first female practising barrister in New South Wales. Roddy Marr from St John's College, legal scholar, former Justice of Court of Appeal. I could go on and on. Many of them came to college, and as you will know, these individuals have lived great lives in law. But you may be aware, and through the good work of Andy Durbach and the Human Rights Commission, and also here the University of New South Wales Law School, there is increasing public scrutiny on the safety of young people at university and in residential college. So my work leading a cultural review into 5 colleges at Sydney University has confirmed for me that young people, far from being disinterested, have a strong desire to step up and shape a more gender equal future. Because college can be a rite of passage for many young people. It's a place to learn about your standing in the world. Men and women come to college wanting to belong, to be respected, to be loved, to feel connected in brotherhood and sisterhood and in the broader community. The problem is that if they have not answered the question, who am I, they often fall at the feet of a darker question, and that is, what price will I pay to fit in? Am I willing to subvert my individual values, my integrity, my ethics, in order to identify with the group? What values will I place on tradition for tradition's sake? Because the problem with tradition is that it can continue well past its use-by date. The White Australia policy was a tradition. The expectation that women would not work once they were married was a tradition. For many of us here, it's a good thing that some of those traditions are no longer traditions. But they didn't just disappear on their own. They disappeared because someone thought differently and had the courage to step up and question the status quo. And the practice of law itself has many traditions, both good and bad. Some of its most fundamental premises, including the principles which evolved from the Magna Carta, were nevertheless developed by and for men of property with nobody else remotely in mind. And this legacy has seen the conventions of a law designed on a foundation of homogeneity, with little appreciation on occasion of difference, of disadvantage, or of otherness. This legacy also meant that for centuries, gendered assumptions about the role of women in society left women without power, disenfranchised, and treated as the property of first their fathers and then their husbands. Tradition has also meant that gendered assumptions about acceptable behaviours of men and women have shaped the law's response to countless issues, from the development of a law of equity through to the responses to sexual assault and gendered violence. And certainly our glacial capacity to recognise family violence, I think, is just one example. And I do today in this oration want to acknowledge the leadership of Minister Fiona Richardson, who just passed away yesterday, was the first ever Minister for Family Violence in Victoria and stood up and took such a strong leadership role on these issues. Because those failures, or these failures to relinquish the harmful effects of tradition, are not just a matter of a distant past. In looking at international research, as I do for my work in colleges, I've read about some of the outdated traditions which still exist in university settings all around the world. The hazing and harassment rituals woven into the fabric of student life. The belief that these rituals will somehow build a stronger group, a group that will accept and conform to social norms. Yet the evidence is clear. In the most comprehensive US survey of hazing ever conducted, it was found that for more than 2/3 of students who had been hazed, there were decidedly negative outcomes affecting their academic achievement, their social interactions, and for some, their life trajectory. And so my work is now focused on the changes that must be made to ensure that every student can thrive within Australia's university system. Of course, there will be some, there may be many, that vehemently disagree that any change is needed, that things are working well just the way they are. But what I've learned over the years is that in order to change any culture, and university culture included, I will need to make space for all views to be aired. This will involve examining and listening to what people value about tradition, but then ensuring that this can be meaningful and positive for all members of the community. Which brings me to my fifth and final important lesson for which my time at University of New South Wales Law has equipped me, and that is the value of engaging with those who may hold and share opposite views to ourselves, at least initially, or indeed who may utterly oppose our views in a respectful exchange of ideas. And for this reason, I was really fascinated to read in Hal Wooten's response to Julian Burnside that Julian had decided to answer every piece of hate mail that he received, which was an act of extraordinary diligence, but also of grace. Through this simple act of courtesy, he displayed to each correspondent, no matter how hostile the correspondence itself had been, that respect for the discussion and on many occasions a change of heart at the other end. And as I said before, I'm keeping this approach front of mind as I engage around the rugby union debates as a member of the ARU board, because what I know is that when you launch into a conversation about change, the conversation is very difficult. Discussions become quickly polarised, and the art is to create a safe space for all views to be aired. But how do you create that safe space? And I think step number one is just so basic, but we often forget it in the emotion of the moment. That first step is, don't assume that those who hold views contrary to yours come with bad intent. Because when you set out in this way, it's so difficult to move a conversation on. Assuming bad intent cuts you off from understanding why someone does something or believes what they do. As Megan Phelps Roper reminds us in her compelling personal narrative about change, she says, "We forget that the other is a human being with a lifetime of experience that shaped their mind, and we get stuck on that first wave of anger, and the conversation has a very hard time ever moving beyond that. But when we assume good, or at least neutral intent, we give our minds a much stronger framework for dialogue. We open up the possibility of change. And when opening up this possibility, we must always remember that the experience of change may be acutely uncomfortable. As Anand Gurdas writes, and he's a fabulous Indian writer, he writes in his letter to all those who have lost in this era, he says, "I now see that there's a subtler, quieter varietal of disadvantage. And that is feeling history to be moving away from you, that the world's becoming less and less familiar, less yours day by day. He continues, I will not concede for a moment that old privileges should not dwindle. They cannot dwindle fast enough. It is for you to learn to live in a new century in which there are no bonuses for showing up with the right skin colour or the right gender. But I will admit, fellow citizen, that I have discounted the burden of coping with the loss of status. I have forgotten that what is socially and organisationally necessary can also be personally gruelling. And I think for those of us who lead, we must be cognizant of this and understand each individual's experience of change, because too many people seek to change things before understanding the investment that each individual has made in what already exists today. This means we have to understand each individual's contribution to the existing structures and systems before trying to change them. Nevertheless, change them we must. And all of this suggests that the role of an advocate for any kind of reform is going to be a difficult one. I have learned through often humbling experiences that it's not just a task of charging in with an indisputable case for reform, all the data, all the metrics, and dismissing the views of any I encounter in my path. What's more, in gathering the many lessons I've accumulated along the way, I've also learnt that the role of advocate and human rights defender is a crucial yet often undervalued one. Throughout this lecture series, we've heard from so many esteemed advocates for democracy, for human rights, for the rule of law. We've heard of Julian Burnside's very conscious decision to speak out in the political fray, despite the hostile response from colleagues in certain quarters. We've heard of the struggles and often serious personal cost of previously unassuming lawyers who felt compelled by their professional obligations to speak out against the erosion of the rule of law in military environments and at Guantanamo Bay. And as I said in the beginning, I worry that we're entering a more complex and dangerous environment right now. And that's not necessarily here in Australia, that is right across the globe. This means that those who advocate for the rights of others are going to be met with increasing resistance. It will become increasingly dangerous. In fact, in my role as a board member of the International Service for Human Rights out of Geneva, an organisation which protects human rights defenders all around the world, particularly from fragile nations, what I know from my work there is that many human rights defenders risk everything. They risk their reputation, yes, but also their family, their lives, to stand up for others in some of the most repressive regimes in the world, in China, in Russia, Saudi Arabia, Honduras, Zimbabwe, to name but a few. And in December 2015, there was a survey conducted by New York University which revealed that although many human rights workers are resilient, human rights work is associated with elevated rates of post-traumatic stress disorder and depression. They even found in that study that PTSD amongst human rights defenders was higher than for veterans returning from Afghanistan, and almost twice as high as it was for people affected by natural disasters. This seems incredible, but when the task is so great, it's perhaps little surprise that many actively engaged in promoting a more gender equal world feel a reluctance to look for support, an unwillingness to put their own needs before the needs of others. Now, we might be forgiven for assuming that this encroaching hostility to the cause of equality and the impacts that it can have for those of us who advocate for it, that it only exists elsewhere in other nations. But instead, in October last year, Michael Forst, the UN Special Rapporteur on Human Rights Defenders, visited Australia, and he stated, "I was astounded to observe what has become frequent public vilification of human rights defenders in a seeming attempt to discredit, intimidate, and discourage them from their legitimate work." And over the last 6 months, in fact, there's been more and more voices claiming that women's rights, that gender equality, inclusion, diversity, these are just examples of identity politics, that we're living in an era of political correctness gone mad, that the women's empowerment agenda is merely the rantings of a feminist left. The attacks that we experience as human rights defenders are a signal, perhaps, of our retreating regard for the rule of law. Political expedience, of course, hastens this retreat when we find our self-view as a nation of compassion diminishing. So if we are to value democracy and the rule of law, then we must value those who advocate for them as well. I say this not as a statement of self-interest, but as a lesson sorely learned, one which I have to say is still a work in progress. But I also say it as a statement of disruption. And while it might not be as big a reach for advocates in privileged positions to suggest that we should look after ourselves and each other's, it is the ultimate act of empowerment for gender equality advocates in so many dangerous places across the world to prioritise their own well-being. As the women's human rights defenders and I say, being well, both physically and mentally, is indeed the ultimate act of political defiance. And indeed, the women's human rights defenders have come together recently. They have put out a fabulous self-care manual which says, what point is the revolution if we can't dance after? So that's where I've come to in my life in law, the foundations of which were laid right here, in fact, right up there in that big ugly building with the brown thing on the top, the foundations which were laid there and for which I'm enormously grateful. I am but one of many restless advocates this law school has produced, and I certainly won't be the last. And to be honest, I feel a little bit torn about sharing my story with you today, because I don't tell it because it's any more important than anyone else's. I share it because it reflects a life of constantly learning from others who, like the father in the dangerous Fatah region in Pakistan last week where I was travelling, he reminded me when he said, after all, what future do I want for my daughter, for the daughters of the world? If people facing this kind of struggle can keep advocating for gender equality, for the possibility of reform, then surely so can we. As we've seen from recent political events around the world, the defence of human rights, of our shared humanity, is becoming more and more challenging. This means that we must support each other and draw strength from each other's experiences. Because Uni of New South Wales Law School taught me that far from following a well-trodden path, a life in the law is about finding your distinctive voice and then using it to challenge the status quo. A life in law should mean working to ensure that the law's not brought to bear unduly on the disadvantaged. A life in law should mean finding what is valuable about tradition and discarding the rest. But most of all, a life in law should mean listening to and learning from the experience of others, recognising that we are only one person, that we don't have all the answers on our own, but that together we can effect change. As one wise woman from an African nation recently told me in the United Nations, she said, doing what you can when you can. That's how you change the world. In times of doubt, that's been my mantra. That's what I go back to, my foundation. Doing what I can when I can. That's how I'll change the world. I invite you to also make this mantra yours. Thank you very much.